Good afternoon and welcome once again to the Polity, reaching you live from the Abuja studios of Kaftan Television. As usual, we'll be bringing to you discussions on the intersection between politics, governance and the state of the nation. A lot has happened leading up to the presidential, afterwards, and now leading up to the governorship elections. We'll be taking an in-depth look into some of the matters that are still in contention ahead of the polls. A lot of updates have come in, and we'll be doing some justice to them. Also, specifically on the legal aspect of things and the judicial ramifications to what we're seeing so far. So, welcome once again. I am Amadin Obawe. I've been joined now by legal practitioner Mr. Kelechi and Wu to break down some of these developments. Welcome. Good afternoon.
Good afternoon, Mr. Amadin.
It's good to have you. Thank you for coming. All right. A lot has happened in the course of the elections, afterwards, the contentions, and now leading up to the governorship elections, which was postponed. But let's start with something that a lot of people might not be aware of. We'll start with that and then go further into the conversation. And I'm talking about the issue of the judgment of the Federal High Court compelling the use of temporary voters' cards. Taking a look at the judgment there, it was between Kofo Worola Olusegun and Wilson Allwell, who were the plaintiffs, and the Independent National Electoral Commission, who was the defendant. This was passed by Justice Obiora Atigu Eguta. He's the judge on the matter. So let's speak about this. What does this mean ahead of the elections? What does it mean in terms of voting and how it could happen? But before you answer, I'd just like to let our viewers know that our phone lines are open, so you can call in and make your contributions. Please go ahead.
Yes, that judgment is a novel one, and considering the situation we are in, in the last election we had issues, we had loopholes, we had people with different challenges, and building up to the governorship election, this judgment that came in, we could see during the last presidential elections, so many persons were unable to exercise their franchise, and which is not what the law says. The law says anybody who has who is of votable age and has complied with the provisions, that is getting access, getting a voter's card and being armed with such voter's card, is eligible to vote. But unfortunately, due to either logistical or whatever reasons, some persons were unable to vote during the presidential election. I feel this judgment allows more people and allows those who were disenfranchised for one reason or the other to vote. But I believe those whose names appear on the voters register and who are eligible to vote should be allowed to vote. That's what I believe, and that's what the law makes us to understand, that those who have appeared, whose name are on the register, are eligible by right to vote in an election.
Do you think perhaps there was a loophole, so to speak, in the Electoral Act, speaking about the necessity for a permanent voter's card? I've voted during the cycle of the use of BVAS, and it really is just a little glance that you have it. I mean, I could hold if someone wants to be, special or be a little bit shifty. I could just flash something that is not the card, as long as they see that, oh, there's something in my hand. Every other process leading up to the actual voting actually doesn't physically require that card, except for the officers to just see that you have it. But other than that, it actually has no specific purpose. So following this judgment, should there be some sort of amendment where it shouldn't be necessary? Because at the end of the day, it really isn't necessary, because once you've shown your card, then they allow you get accredited. And before that, you would have seen if your name is on the unit or not. So it's almost as though the card is redundant.
It's a process, like we rightly say. It's a process that has been undermined over the years. It's just those who are in charge are not letting go of the old ways and embracing that it's a technological error. This is an era where you do not need to do things manually anymore. Now, we have the voters registers are they are not booklets. They are data papers that are contained both online and offline. We have both the booklet and the online means. Now, those data are contained in those platforms that you can be able to access with your voters card. Now, persons who have the permanent voters card are by reasons persons who have the INEC identification number. And in the last election, what most persons used in accreditation were basically like, for instance, in my polling unit where I voted in Olanwinebonyi State, where I voted, what was basically used in identifying someone is when you bring your permanent voters card forth, they look at the last digits on the card, key it into the beavers, and then you thumbprint, affirming that you are the person or you are not the person. Now, in such circumstances, if your name is on the on the voters register, which is on their database, the system will automatically tick you good, and it means you are open to voting. But in the light of this judgment, it puts it makes it difficult for those who are not able to access. There are persons who are not able to access their voters card but had those numbers. Now they have right to vote. It wasn't their making that they were not able to get their permanent voters card. They already registered. They have their temporary. And the most important thing, as far as the whole election cycle, is those identical numbers. From what we are meant to know, two persons cannot have the same number. So it's peculiar to just one person. So this judgment puts it's at a difficulty for those who were not issued with a permanent voters card, who were not out of their own making. They were either by the negligence of the INEC officials, or just like a few days ago, news broke up that a farmer in Abuja discovered voters card of people from Kwara State and even Bauchi. Now, within the build-up to the election, a hunter in Anambra discovered inside the bush the over 1,000 permanent voters card. Few weeks ago, the army intercepted voters card in Lagos, over 1,000 voters card. Now, these are not these persons have out of their own gone out to register. And you don't understand that we live in a country where actions do not have consequences. Because if these actions have consequences, by right, every person who registers ought to vote. Every person who registers ought to have their permanent voters card. By right, you should enforce your rights to have your permanent voters card. As long as you've been registered and as long as your name is in the register, it is your right to have access to those permanent registers. But in Nigeria, we have a situation where there are no consequences for actions and nobody takes blame for anything. People who queued up and made their registrations were not able to be given their voters card, and now they are being disenfranchised by the situations of this judgment.
That's interesting. Well, it still puts into question the true necessity of the card, because as long as those numbers are available, your identity is still going to show up and they can verify on their own systems. But that aside, away from the legal aspect, do you think this would or in any way do temporary voters cards even exist? I ask in terms of people who begun the process of registration, is there any way they have access to the numbers on that card?
Yes. Yes. You know, at the point of registration, you're given a temporary slip.
Yes.
And those slip contains your number.
Is that what ends up on the permanent voters?
Exactly. Those are the numbers that end up on your permanent, that VIN number, that voters identification number. That is the voters identification number. It's peculiar to just you and you alone. No other person has the same identical number, the same number. Now, that number is the same number that will appear on your permanent voters card. And even when you check your details, your data on the INEC website, what pops out are your details, and it has the VIN number, which is the voter's identification number. So it's still the same thing. The only thing is that the other one comes in a very durable plastic and has your pictures on it, while the other one has just the rights of the inscriptions on it. Now, these numbers are as it were, these numbers are your numbers, and these numbers goes to show that you have you have a data on the INEC sources, the INEC register. Now this number allocates that you have been registered to vote. So it now becomes very hard for you on your part if you're disenfranchised, if you're asked not to vote by reasons of you not being with a permanent voter's card which is not out of your own making.
All right, so I think that's really the issue at hand. Now, I'd like to speak to issues of voter apathy and some of the things we've seen, you know, reactions we've seen from people after the results were announced. Some persons are feeling a bit apathetic and saying, you know, based on what happened, I might not want to vote again. Others are gingered and so on. Away from the legal aspect, what do you think this could do in terms of getting people to come out? Two questions here. What do you think this could do, knowing now that your temporary voter's card is enough for you to vote? Do you envision a hidden majority who were hitherto unable to cast their votes now having that liberty to do so? Do you think they will come out? And then second, what happens in places where some polling units, we had reports that some polling units have already accepted, you know, this temporary voter's card even before this pronouncement? What happens in those places? Are there, is it liable to cause overvoting because the number of registered voters or number of PVC collected is not equal to, I don't know, could there be discrepancies there that could put the election in jeopardy?
Now the problem is that was recorded from the last election and which can be seen visible, where first that we are actually serious voter apathy, and you could see from the numbers we have over 93 million people who registered for that election, and we have barely less than 30 million that voted. That means we have a more sufficient number, a more substantial number who were apathetic to voting and who could not exercise their franchise by one reason or the other. Now, this situation now puts them into more doubt of, one, the credibility of the process, and two, it makes, considering that, one, there were no proper voters education prior to this election. There are some places you get into and you ask, they do not even know what it means, and the language you speak about the elections, and they only know, they just want to vote. The all other things you speak about, permanent voters card and temporary voters card, they cannot even, the only is that they're registered, they're expectant to vote, and they already know most of them already know who they want to vote for. And some do know who they should vote for, but they do not want to vote. And in these circumstances, considering that we had serious voter apathy in the last election, which was the presidential election, now it now boils, it gives concern for a more apathy towards people coming out to cast their vote on Saturday. Reason being that, one, with the event of the last presidential election and how it went, you could see even from the pictures and videos we saw online, people destroying their voters card in the circumstances, and you see people have serious doubt about the credibility of the process, and it undermines their chances of coming out. So, and this is not, it does not tell well on a good election and the way an election should go.
All right, we'll wait and see what this does for people to come out. Hopefully they do. We've been saying that here repeatedly, whatever issues you had with the presidential elections, whatever you feel was done, it's easier for those things to be done when you don't come out and vote. So I do hope more people come out to vote. Now, let's move over to the more general issues, but still on the judicial aspect. We talked a lot about the Naira swap policy before the elections, and I'm sure you're aware of the updates now. So I had a legal practitioner here the other day, and I asked him, at what point does the Supreme Court judgment take, will I say take charge, or becomes law, so to speak? Or at what point can I, after hearing about that judgment, as a citizen, I have an old 500 Naira notes, and I've heard that law, can I immediately start spending it? Or is there still an in-between where the president or the CBN governor have to come out and say, for sure, we are going to do what the Supreme Court said we should do? Because what happened in the near past was that after the Supreme Court said one thing, the president made a broadcast where he said, 200 Naira remains, the rest no. It felt as though, and he indicated in that statement that he's aware of court rulings or court pronouncements. So it felt as though he heard the court announcements, then he told Nigerians this is what to do. So Nigerians are wondering now, what is the way forward? With this judgment, it's been over a week now, and we've not heard anything. We don't even know what's going on.
Now, the question you asked about the Supreme Court, their pronouncement when it takes effect, I must emphasize that the Supreme Court is the law. Their pronouncement is law itself. They are the last court. Any court of law is the law itself. Their pronouncements are the law until it is set aside. And in the case of the Supreme Court, they are the apex court. So their decisions cannot be set aside, or the only situation is that they overrule themselves. But in this situation, in this present situation now, we have the Supreme Court giving their ruling and their judgment on that matter. That becomes effective from the day it was given. It becomes law the day it was given, it was delivered.
Sorry to cut you short. What about the issue that, in the beginning we talked about the CBN not being a party to that suit?
That has been overtaken by events.
My point is, the CBN or the CBN governor, wherever they are seated, and they say, okay, we've heard the judgment, but we're not a party to that, so
that has been overtaken by event. That has been overtaken by first the Supreme Court assuming jurisdiction and inclining that the CBN is an agent of the government, and by extension they are bound by whatever pronouncement. By virtue of our constitution, our constitution empower the judgment of the Supreme Court is enforced all around Nigeria, in all the states of the Nigerian Federation, including the FCT. Now, when I say it has been overtaken by event, it means they have been subsumed into the number of persons who are going to obey that judgment, and includes everybody in Nigeria. Now, at the moment, you have a remedy where you present, if you have a cash, you are at liberty to spend your cash. You are at liberty to offer such money. The Supreme Court has pronounced that it's still a legal tender, and so it is. Now, if I give you my old 500 Naira note, and you say you are not taking, I am at liberty to initiate a proper action against you, because you are now in breach of the law. You are now in breach of the CBN judgment. It is the law, and it is the law it is. Now, such situations now, we could understand that there has been a drag leg over the implementation, but then the law is the law. No matter how long it takes for people to understand that this is the way forward. The old Naira note is a legal tender, and the Supreme Court has pronounced it will be to the end of this year, to the last day of this year. It will be, and any transaction you intend to make that can be made in cash, you are entitled to make it. So nobody is at liberty to reject your cash. Nobody is at liberty except they have an alternative for you to make payment.
All right.
Like if somebody say he's not taking your cash, he should have an alternative. But you can't reject your cash and also not have an alternative.
All right. The question now is, in terms of accepting of the payment and all that, and people not wanting to comply, or let's leave Nigerians or the average Nigerian. Let's go back to the people who are meant to enforce. I was having a conversation, and there was a breakdown that the judiciary, in one respect, can be said to be the weakest of the three branches of government, because even though it can make pronouncements, it cannot execute it. Now, speaking of that execution, there have been talks here and there that if the government is mum or not actively doing as the Supreme Court says, there could be repercussions. Is that something that's possible, specifically for the Attorney General, that it could be stripped of his post and all that?
The Attorney General, there are repercussions to Nigerians who do not enjoy immunity. You understand what I mean? Like there are repercussions for Nigerians who are not governors and who are not president and vice president. Now, for those who are not enjoying immunities, you could initiate a content proceeding, and if it is seen that they've committed content extracurricular, they could be liable to whatever sentence the court decides to pass on them. If the court decides to order the person's arrest, even a human being on the street can effect the arrest. If the court, even the orderly of the judge can effect the arrest. At the moment the court issues the arrest, you are bound by that. Anybody closest to you, if any person is ordered to make the arrest, you are to make such arrest, including private citizens. So there are repercussions for failure to abide by the judgment of the Supreme Court. Now, over the weekend, we heard of the governors intending to initiate a content proceeding. It is available. Such options are available in law, because failure to obey a court order, it's tantamount to lawlessness. So if in such situations the Supreme Court considers that the order has not been obeyed by certain persons, but it's not for you to say this person has not been obeying orders. It's also for you to come and show cause how this person has failed, what are his actions or his omissions. Are there things he was supposed to do? Now, if you say the Attorney General has failed to obey the court order, what has the Attorney General done? What steps has he taken? Any steps ever since then? Has anything has he carried out? Failed to do anything that he was constitutionally permitted to do? So these are things you put into consideration. It is not a straitjacketed situation that you say someone has not failed to obey a court order and then he commits content extracurricular. So in such circumstances, you must show cause why he should be an order of committal should be awarded against him.
All right, so that's fair enough. Like you said, the state governments they have warned that if by Tuesday they do not see proper implementation, they will, restart the case. Like you said, issue a case on contempt. Now, let's talk about the after effect or aftermath of the elections, and still on court process. We have that the PDP and the Labour Party have reportedly taken the APC to court, and the APC themselves, interestingly, have also sought to access the electoral materials. Now, let's talk about that, the recent judgment at the appeal court, which gave INEC the go-ahead to reconfigure the BVAS machines, but after they've, backed up the data in the BVAS to a back end to allow it to be viewed. Now, we have that the Labour Party is complaining that since the judgment has been given or passed, they've still not had access to those machines. I'd like to paint a scenario. What happens on the off chance that they don't end up, being able to access those machines and they are reconfigured and they go ahead with the governorship elections. Is that a plus or a negative to their case?
It is a negative to their case. However, there are...
But even though the INEC didn't comply?
Yes. At the moment, under our law, upon the announcement of a result, the party who wasn't declared a winner is given a window of 21 days to bring up his action. As of today, it is March 13th, and that result was declared on 1st of March. Yes. And as of today, if you minus 13 from 21, you will have the number of days they still have left. Now, the Labour Party and PDP are saying INEC and whichever party that is involved in all this is playing hanky-panky. And in the light of the situation, can be argued that the court has issued an order. The court has made an order. Obedience to the rule of law is paramount. It is the first thing any institution, most especially the government institution, should do. They should lead by example. The court has delivered its ruling and have given an order for you to allow these persons to inspect this thing. If by adventure, and considering that they have a timeline upon which to bring the action. So if they don't bring this action within this period, it could affect their chances of presenting an all-inclusive case and their evidence. Now, within this period, the INEC is doing all this. They are not allowed to tamper with any of those things. Certainly, when they feel they feel they want to configure, which the Court of Appeal has granted, they want to configure the beavers. Yes, you are allowed to configure the beavers, but that should not derogate the order that the court has also. Both can run concurrently. While you're configuring the beaver, please allow the other parties access to inspect. Maybe you could schedule a timeline for them to inspect, but you must give them that that entrance to the data. That you must give them that allowance to inspect and verify the data that are available on you.
But what is it about, or what is it this difficulty about simply following court judgments?
It is bigger than it is. There is more than meet the eye. Now I feel it might be a sentimental opinion, but if there was nothing to hide, parties should be able to allow. These are public data. The institutions are public institutions, and by our law, people are allowed to see public figures and data that are available. By our Freedom of Information Act to start with, you have access to records kept by public. So INEC
but they say there are sensitive materials.
It does not change anything. The only thing is you are not allowed to alter anything. If this is a public office, I have the right to inspect this, whatever that is in this room, but I am not allowed to take anything out of this room or alter the form or substance of it. I am allowed to see what is in this room, so I can be able to make a description of what it is. I am allowed to say, okay, this place look white, this place look green. I have seen it, I have witnessed it, but I am not allowed to either remove the green or remove the white or add white to the green. Those are the situations of the INEC. Now, you are allowed, as long as a public institution has any data, any record at all, the law allows you unfettered access to any of those records, except the ones that are marked as secret or confidential, of which none of this has been marked as a secret or confidential file of the government. Now, in those situations, going against those orders that have been granted will likely cost the person. It's just that there is no consequences for actions. If there were consequences for actions,
what is a possible consequence here?
The consequence of the action is that those that are involved should be sleeping in Kuje or Suleja prison by now.
Who would that mean? Does that mean the council of INEC or INEC?
No, the council is an independent contractor. He has nothing to do with INEC.
Okay.
The INEC staffs who are in charge of the data, the INEC chairman, whoever that passes his table, that was supposed to attend to these things within this period, they should be sleeping in Kuje prison by now. If there were countries that look at the consequences of actions. In fact, we should get to a point where government officials should be afraid of their impunity, because this kind of impunity can only deteriorate the system more. You have been given a simple order. The order is allow these people access to this server. They did not say they should take it to their houses. They can inspect it in your offices. They can look at it, what it looks like. Nobody asks you to give it to them to go home and probably bring it. You can't set up a center where they assess these things, and these things are not too hard. They are not too hard. It can be done even in 1 or 2 days.
All right, let me quickly read out something from INEC here. The Independent National Electoral Commission has slammed political parties intruding into its affairs to dictate on how it should operate the bimodal voter accreditation system. Mr. Festus Okoye, the INEC National Chairman and Commissioner in charge of voter education, made this known on Sunday. He stressed that it is INEC's function to regulate the affairs of political parties and not vice versa.
That is absurd. That is totally absurd. Now, INEC does not operate in the limbo. It operates through a legal framework. INEC has a law and regulations that guide its operation. INEC do not just wake up by maybe a member of the INEC. INEC is not a person. It's an institution. The only thing is that institutions, it is not run by one person. It is run by collective decisions of institution, and by both the Constitution, the INEC, the Electoral Act, the INEC guidelines for 2023 general election. These are laws that regulate the conduct of INEC, and these laws provide these things, and these are laws upon which the court has examined, and the political parties will not just wake up one day. If you go beyond the provisions that have been set up for you, let's assume there are things. INEC is not a totalitarian institution. It does not just make a decision on its own. It follows a process, a procedure, a non-procedure, a written procedure. So it cannot go beyond. It cannot fault on its own procedures.
All right, let's talk about one in particular. There's a judgment here. The judgment says, it's from Justice Emeka Nwite of the Federal High Court in Abuja. This was on Friday, I think, this past Friday. It says that only INEC can determine mode of collating, transmitting results. Going further into the judgment, it says, that Section 60, subsection 5 of the Electoral Act 2022 provides for the transfer of election results, including the total number of accredited voters from the polling unit, adding that Section 62, subsection 2 of the same Act provides for compilation, maintenance, and continuous update of the register election result as a distinct database for all polling units. Justice Nwite held that the said Section 62, subsection 2 has mandated that such register of election results shall be kept in an electronic format by the electoral body. What do you make of this? The argument now, which is something that we heard a little bit of at the Collation Center when Senator Dino Melaye got up and challenged the process and said that the results being read were not online. They were not transmitted from the polling units. And the INEC chairman mentioned something about INEC having the authority to review. So that's I think that is becoming the bone of contention.
People make this mistake.
Can they really review at any point whether to
they had 7 days to review.
Okay, it's has to happen
yes,
before.
they had 7 days to review by provisions of the Electoral Act. But then let me take you through this narrow line.
Okay.
Now, Section 60, part of the Section 60 provides that the elections could be conducted in the manner prescribed by INEC. Now, INEC on its own, with nobody asking for it, brought out a guideline. What does a guideline mean? It means a procedure to follow. Things we will do. You cannot do anything outside what you've provided for. And these guidelines are made pursuant to a sitting. The distinction I was calling earlier is that people should be able to make a distinction between the INEC chairman and the INEC. The INEC chairman is not INEC. He is a chairman of INEC. Now, INEC is an institution. An institution that has a board. And the INEC chairman is the chairman of it. Now, there are other board members that sit and make these decisions. You get clearly.
Yes.
Now, this, by the provision of that section 60, it gives INEC that unfettered discretion to make laws, what we call an administrative law, a bylaw that can abide by. Now, it does. INEC do not need to go to the National Assembly again to make these regulations. These regulations are an addendum to what the Electoral Act comes. Now, this regulation comes as what we call the INEC guideline, and by section 38 of the INEC guideline, it provides means of, from the polling unit, you transmit this result to the INEC server. From there, you put it to the ward, to the local government, to state, and to the national collection. So you do not derogate from these provisions you have made. Nobody made these laws for you. You sat down with your boards, your chairman, and whoever that is there, made these INEC guidelines, signed on it, disseminated it across all boards. You even went online in international forums, canvassing that this is the way. By your own guidelines, citing your own guideline. Your own guideline becomes operational. It was your own guideline that were followed by political parties. It was your guideline that gave rise to events that got to the general election.
But it seems as though the mindset is that at any time they can change. If it's 2 hours after election,
who changes? The question is who changes? Is it the INEC chairman or the INEC itself? The distinction should be between the INEC chairman and INEC. Now, if you have a regulation, by the word of the chairman, you cannot change the regulation your board, an entire board has made. If an entire board has taken a decision and you make this regulation, now the regulation opens for amendment, but that amendment must be inclusive. It cannot be taken by one person. Let's say I am a member of Kaftan, and there is a regulation upon which Kaftan works on, and by reasons, let's say I'm a director in Kaftan, and there are like 10 other directors. I wake up one morning and I take decisions for the 10 directors. Well, the regulation says it can be amended at any time, and for you to amend those things, for you to make such alteration, it must be a collective alteration, and you must also publish it through those means. Now, those ones were casual side talks that were made during the collation. They were not valid laws. They were side talks. Now, every other thing that can it be relied on? The comments that were made, can their comments during the collation be relied on? The question is no.
But if you say this, what you're saying about guidelines, so what are we to expect on March 18? As a citizen when you are voting, can you demand that the officer there send it to the polling unit?
That guideline has not been amended, and it stands as it is. Until if by 17, well, let's not preempt ourselves. If by 17, what about if by 17th INEC decides to issue a new guideline or an amendment to the guideline? But at the moment, yes, the law allows them to do, but it must be inclusive. It must be extensive. What are the
time? You mentioned the time. If they want to change guidelines for governorship elections, when do they have or when do they need to?
The law does not provide when they change guideline. But if you must change it, you must change it through the right means. And the right means will be not just one person waking up and saying, we have changed this. But you adopting, okay, after a thorough sitting of the board of INEC, the members of the INEC, we have agreed that due to changes due to circumstances experienced in the last election, this so and so is the new way forward. But until that is done, the guideline that has been brought, that is called the 2023 General Election Guideline, operates, and it is what it is.
Well, I think we're in a dire situation then, because a lot of Nigerians are not sure. There's still, as we speak, it's been February 25 to now is quite some time. We still don't know exactly
any derogation from that guideline is a breach of the guideline.
But what do you make of the communication, so to speak? Till now, I don't think there's been any official reply to the people that this is the reason we suddenly did not do what we said we would do for months or perhaps even years. You know, so what do you think is happening?
That is to tell you the kind of institutions that we have, and people who have no consequences do not follow actions. If people,
but they were so sure. They repeated this.
Exactly. For you to waste 300 billion naira of Nigerian taxpayers' money, my money, your money, and at the end of the day, you are unable to get this kind of thing. I tell you, if this were to be a country where things are working well, some persons will be facing a court of law for criminal charges, because it is criminal for you to amass and expend such amount of budget and you are unable to deliver on the mandate. A simple task. If a simple task that if you give anybody with such amount, that amount is enough to generate you what you want. Well, if for you to waste such amount and at the end of the day we are still having this complaint, somebody should be cited for criminal charges. Now, going forward, the election will hold, and it will hold according to the guideline that is on ground, not according to the comments made by an INEC staff. It will hold according to the guideline issued. For INEC to issue, just like you said you were waiting for a statement, that statement, it takes a thorough meeting, an agreement for you to issue, a government office to issue a statement. You do not just issue a statement on your own. Now, you as a staff can make a bypass comment. Do we hold you for your comments? No. We hold you by a statement you've issued and a guideline you've signed. An official, you may only, anything not made in the official stand is a bypass communication.
All right. Let's talk about an issue that the election was brought up. You know, I'm doing my best to get as much opinions as I can from legal practitioners on this issue. The issue of 25% in at least 2/3 of the states and the FCT. There's been a lot of contention about the clause in the Constitution because people say that in this election, the person who has been declared president-elect did not get the minimum 25% in the FCT. And the question now is it, what is the proper or the right interpretation to that clause? Does it mean you have to get 25% in 25 states, or you have to get 25% in at least 24 states and, you know, plus the FCT?
Everybody who has made comments about that 25% is giving a gesticulation. Because one, that particular provision has never been tested by the court of law. Now, it is not, none of us, even lawyers are not there to interpret the law. Their own is to provide analysis and provide opinions. Those opinions are not binding on any of the court. They are persuasive. It is for the court, in its wisdom, because we presume that the court knows the law. Now, it is for the court to pronounce on that ground. You can ask 10 lawyers and they will give you different opinions. Now, if you ask me about the opinion, I am giving you an opinion based on my own analysis and my own understanding. Now, until a court pronounces on that section 34 sub 4, you cannot have an extensive over the past 2 weeks, you've seen different lawyers give different opinions of what they feel. It's not it is neither here nor there. the opinions are of mere persuasive. These are people's arguments. These are arguments. These are opinions. They are of mere persuasive. Their own is just to analyze and submit it to the court. The court takes the decision and look at it. Well, if I am to delve into that situation now, I will tell you, by the operative word of that section, it says 25% in all the state and the FCT. Now, if we use our grammatical knowledge and understanding in interpretation, now when there are words that are conjunctive, like and, when there are words like and, it distinguishes that these words are together. That is my own analysis. When a word like and is used, when I say give this thing to Ahmadine and Rose, it means you're giving it to two people. You're giving it to these same persons. But when I say give it to Ahmadine or Rose, it means you're giving it to two different people. Now, you could say, if I feel the intendment of the draftman as it pertains to section 34 sub 4 is to the effect that Abuja is regarded as a state. All you need, if you do an arithmetic summation of the states, if you add, it becomes 37. It makes it 37. And when you put up that 25%, that 25% into two-thirds of 37 will give you 24.6, of which if you round the number up, it will be 25. So expectantly, you are to get 25. That argument about getting 25 in Abuja specifically, I do not subscribe to the argument.
Right, I once had an analogy, I don't know if it works here, where you are giving an order, okay, I want you to call children for me, and I say call 2 children and Peter. And people say, if you go out there and you bring 3 children and Peter is not among, does it count?
Exactly what I'm saying. Exactly what I'm saying. It means you are counting 2, 3, you're looking for 3 human beings. You're looking for 3 human beings. Now, the mention of Peter does not exclude that you must bring in 2 children. Now, what that says is you must bring 3 human beings. They are looking at 3 human beings.
But doesn't it also mean Peter must be among them?
It means there must be a human being. You understand? It means you must bring 3 human beings, which Peter must be among. It does not say whether you're bringing girl or boy, whether you brought in boy or girl. Now, the expectation is that you bring in 3 people, which Peter must be among. You get? Now, the why Abuja was referred to is because in the normal stance, Abuja is always referred to as Abuja. It is not referred to as state, but the status for the purposes of election, Abuja was granted that power, that privilege of being a state. But in other stands, you understand, Abuja does not have Abuja. When you count 36 states, you count 36 states and Abuja. Why not remove Abuja? If you feel, why do Abuja have senators? Why do they have House of Reps? Well, for the purposes of anything, the Constitution also provides that for the purposes of anything that is done to states, you should regard Abuja in such light. Now, it is fair that you mention Abuja. When you say 36 states and Abuja, it means you are including Abuja as one of the states. Invariably, without classifying it as with the nomenclature of a state, because there is nothing like Abuja state. If there was an Abuja state, you would ordinarily say 27. But if you put Abuja inside 37 states, Abuja cannot be classified as 37 state outrightly. But for the status, it acquires that status of a state, and that is why you have the mention of 36 states and Abuja. it comes and conjoins Abuja with that other states and makes it 37 in numerical value.
All right. You know, the funny thing with the law is you would always hear great arguments on both sides, but at the end of the day, we'll have to leave it to the courts to finally decide. But do you think this will be one of the issues, or is it already one of the issues?
It is already one of the issues. There are, like in election petition tribunal, there are 3 things you put to the court. There are 3 grounds upon which you bring into the court. Now, one of the grounds is that you won by the lawful number of vote cast. And can you win by the lawful number? That is inside this lawful number of vote cast. This Abuja issue is top notch. Now, the second one is the person qualification to contest the election. And the third one is that the procedures and processes and electoral regulations were not followed. Now, any of these grounds, any of these 3 grounds, is enough to vitiate a winning or cancel an election. One of the grounds is enough to cancel an election, because if you're able to prove that the regulatory frameworks, the electoral framework were not followed and the elections were marred by irregularities, it means you must you might likely cancel the election and conduct. But if you are able to prove that you have scored a lawful number of vote cast, and if the court rules that Abuja scoring 25% in Abuja is the lawful number of vote cast, it means you must need to score 25 number of vote cast. But if the court rules that you do not need to score 25% in Abuja, it means if you score 25% in 25 states, which is you are good to go.
All right. The question, you know, just for sake of hypothesis, what happens if the court, you know, indeed says what this means? Our interpretation of this is that you have to get 25% in the FCT.
It will cancel. That is, it will. So it will not need it. If that ground succeed, the first ground succeed, you will need to go to the second ground. What
is the second ground?
The second
you mean in the tribunal?
Yes.
Oh, okay.
If you succeed with the first ground, there won't be any need to proceed to the second ground, which is qualification.
But the question now is, what does it mean for the election? Does it mean the election is cancelled automatically?
No. Does it mean the election is if the court rules now, assuming without considering now that the court rules that you must get 25% votes in Abuja, it means that is one. The Constitution also provides that you must get 25% in 2/3. So if the court rules that Abuja is distinct, that means you must get in 24 states. Now, if you got in 36 states and you are unable to get Abuja, that means if you have been given certificate of return, it will be withdrawn.
Yeah, but the issue now,
if there is nobody that got that 25% of vote,
yes,
in Abuja and 24 states.
What about using our current issue? Only one person of the 3 frontline candidates, only one person got that, and only one other person got the other parts.
That is just one of the one.
Yes, exactly. That's the point.
Now the question, the second question will be: did he get 25% in 24 other states?
He didn't. If he doesn't, what does that mean?
Now we go to a rerun election.
But the question now is
not fresh. There is distinction between fresh election and the rerun election. But if this election is cancelled on the basis of irregularities and non-compliance with the electoral law, the correct order to be made is cancellation of the election. But assuming yes, they'll cancel the election. But assuming the court rules that you must get 25% in FCT and you must also get 25% in 24 states. Now, it means since nobody got 25% in 25 states and got 25% in FCT, they will order for a rerun. Yes.
Yeah, but the question is that rerun, how does it work in terms of the fact that only one, let me put it this way, one candidate got 25% in over 25 states, but didn't get in the FCT.
Don't forget.
The other one got in the FCT, but didn't get up to 25 states.
Don't forget there are other grounds that are included in the election petition. Qualification. Are you qualified?
No, the issue now that I want to break down is
that might not be the first ground.
What qualified for a rerun? That is the issue.
What if a candidate is not qualified to stand for the election?
I think most, I think at least two of the candidates have already. They've already been taken to court. I know the former Minister of State for Education, Chukwuma Nwajuba, took the APC presidential candidate to court about some issues. I think it had
his issues were that there were vote buying at the primaries.
Qualifications.
There were vote buying at the primaries. Now, the question to ask again is, and his case was thrown out of court because he commenced that matter after 14 days. You must commence your pre-election matters within 14 days of the occurrence. Now, if you commence that pre-election matter after 14 days from the primaries, that suit was commenced after 14 days of the primaries, and it was not too bad. And that was the reason for the decision. Now, it is left for these parties at the tribunal at the moment. The 18 political parties, the 18 of them, 18 candidates and their political parties. Anyone who wishes to challenge will challenge.
But why do you think this wasn't done as part of pre-election matters? Why didn't any of these parties?
You have a choice. You have a choice either to do it as a pre-election matter or post-election. Now, if you do it in pre-election matter, you might not have all the evidence you need. You might not also have all that you need. Since you are already a candidate, it is only if you are an aspirant, let's say you lost at the primaries, and you know you're not crossing over as a candidate, you can initiate it as a pre-election matter. But if you're a candidate who still have chances at the election tribunal, why the rush? Sit down quietly, make your findings, gather all your evidence from now till within the 9 months it lasted. Now, by 9 months, you would have had all the evidence you intend to call and bring them up for hearing. At the tribunal, it should be your first ground. Let's determine if we are qualified. If we are qualified, we'll go ahead. But if we are not qualified, let the person get out.
All right. So now, back to the issue of rerun. How is it now determined who gets to be part of the rerun?
Now, in the election petition tribunal, if the election petition tribunal orders for a rerun, now the two people with the highest vote. Now, don't forget, people are still going to prove the number of votes they got in the election. So there might either be addition or subtraction during the election tribunal, or it might remain the same. If you're able to prove that you have the highest number of vote cast, and the court agrees with you that you have the highest number of vote cast, but if the highest number of vote cast is not enough to make the 25% in 24 states and the FCT assuming they rule that way, now the two people with the highest number of votes will contest against each other for rerun. The election will be set against each other. They will proceed. That is on the situation where court did not disqualify anybody. But if court disqualifies anybody, the last two people with the highest number will face each other on rerun.
All right, so I think we've finally got that down. Thank you so much for coming, and we hope ahead of the elections we get to still hear from you and get more updates as to what's really going on and how the issues are panning out in the polity. Thanks for coming. It's been
Thank you so much for having me.
All right. That's all we'll take on the polity for today. I'll leave you now with updates over the week to keep you up to speed as we head towards March 18, where elections will be holding in across the states in Nigeria. There are some off-season elections, for instance, Edo State, Ondo State, Anambra, Ekiti, Osun. These states will not be having governorship elections, but could be having state assembly elections. That being said, we do continue to advocate for the electorate out there to do their best to go out and vote. Things might not be as clear as possible, but like I always say, and like it's always said, going out there makes it much less likely for magic to happen, so to speak. We see citizens, or we see cases of where citizens have not only cast their votes, they've stayed behind, they've provided shelter, they've provided generator, they've provided network, they've provided all that is necessary, encouragement, and in some parts a willingness to not allow themselves be defrauded, just in a bid to ensure that their votes count. I will hope to see more of this come March 18. So no matter how you feel about the election results, be it sad or good or happy, don't give up. Do go out there and cast your vote once again. At the end of the day, the people's will prevail. Thank you so much for being with us today. I'll leave you now with some updates and see you tomorrow. And across the weekdays, 2 p.m. to 3:30 p.m., the Polity comes to you live on Kaftan Television from Abuja. Have a nice day. I'm Amadou.